Good afternoon, everybody, and welcome to the second Frank Rhodes lecture for this academic year. My name is Minu Aip, Vice Chair and Managing Director of the University Design Institute, and we host these lecture series for the ASU community. I'm absolutely delighted that we have Dean Erwin Chemerinsky with us today to talk about free speech on campus. But before we introduce him and go into the lecture, I'd like to take a couple of minutes to introduce the lecture series itself. Dr. Crow created the lecture series in 2011 in honor of Dr. Frank Rhodes, who was the president of Cornell University from 1977 to 1995. Frank Rhodes is considered one of the most impactful presidents of the 20th century, and he was driving a vision to fundamentally change the educational and cultural landscape of higher education here in the United States. During his almost 22-year tenure at Cornell, he changed the course of the university in some key ways. His unfailing drive and perseverance to bolster student and faculty diversity is highly lauded. He increased the number of women and minority faculty numbers, actually doubling those numbers, and nearly tripling the percentage of minority students on campus. Research funding during his tenure increased from 88 million to over 300 million annually, and he led successful fundraising campaigns to redesign the Cornell landscape for generations to come. In 2001, he published a book called Creation of the Future, which discussed the responsibilities and possibilities of American higher education. The ideas in this book were so powerful and so influential, they were foundational to the idea of the new American university that serves as sort of a foundation for us here at ASU. So we honor Frank Rhodes and his vision to fundamentally change the landscape of higher education through these lecture series. The invitees to deliver the lectures are experts and leaders in the higher education space. They are thinkers who help to advance important ideas. They have boldly championed important ideas for higher education. And they really are people who force us and other members of the higher education community to really think hard about the design of higher education as it exists and the design of higher education as it needs to be going forward. So these lectures are meant to inspire us, to inform us, to educate us, and to really be thought-provoking and to challenge our thinking as we move the ASU community forward, but also think more broadly about the challenges that are in front of us as the higher education community. Dr. Crow was unable to join the lecture in person today, so we are going to play an introductory video in just a moment. But before we get there, a couple of housekeeping items. Dean Chemerinsky will deliver his lecture for about 20 to 25 minutes, and then we will go into a discussion session. Please use the Q&A function on the bottom of your screen to put in your questions. You're welcome to put in your questions during the lecture or after the lecture. I will try to get to as many of them as possible. We are recording the lecture. We recognize that many can't make it at the exact same time. So the recording will be posted on the Frank Rhodes Lecture Series website. Please look at the recording if you would like to see it again, but please also feel free to share it with your colleagues and friends in the larger ASU community. This is going to be an important conversation for us. So with that, I'm going to have our team play the introductory video by Dr. Crow, and then we will move into the lecture itself.
Michael Crow here, President, Arizona State University. It's really an honor here for the Frank Rhodes lecture to have Erwin here with us today to really help us to continue our process of evolving the model of the new American university, which is a university built on the most inclusive approach to ideas and thinking and people possible for our democracy to ultimately be successful. That means then at the heart of our overall design process is an open, free speech, activated, open to all ideas place in which we have to design within all of those goals a functioning, working, livable, respectful institution of thinkers and scholars and dreamers and doers. And Erwin and his work are going to activate our thinking on free speech, how to protect it, how to advance it, how to implement it, how to make it work actually on the ground, all these things. And so it's really exciting that we can have Erwin here with us, and it's going to be a great discussion and a great next step in our Frank Rhodes lecture series on how to build a new American university. Thank you.
Erwin, thank you again for accepting our invitation. We are delighted to have you. Let me turn it over to you.
Thank you so much. It's truly an honor and a great pleasure to be part of this lecture series. I very much thank President Crow for inviting me. As long as there have been colleges and universities, there have been difficult issues with regard to free speech. Just the last month has seen so many hard questions with regard to free speech in my law school, on my campus, and in campus all over the country. What I was asked to do is talk about general principles with regard to free speech that should guide our discussion of the issue. I'm then glad to take any questions about it. And I thought what I would do is make 4 points. First, all ideas and views can be expressed on a college campus, period. The very core of the First Amendment is that the government can never prohibit an idea or viewpoint from being expressed, even if it's a very deeply offensive idea or viewpoint. I could identify so many Supreme Court cases that have articulated this principle. Let me just mention one from a decade ago. It's a case called Snyder versus Phelps. It involves a small church out of Topeka, Kansas, the Westboro Baptist Church. They have the practice of going to funerals of those who died in military service and use them as the occasion for expressing a very vile anti-gay, anti-lesbian message. Matthew Snyder was a Marine who died in military service in Iraq. The members of the Westboro Baptist Church went to his funeral in the state of Maryland. Before the funeral began, they asked police officers where they could stand, and the officer pointed a place about 1,000 feet away for the funeral to occur. Before the funeral, they chanted and sang. During the funeral, they were silent. They were not disruptive, but they held up signs. The signs were quite offensive. That night, Matthew Snyder's father, Albert Snyder, was watching the news. He was able to read the signs, and he was deeply offended. He sued the members of the Westboro Baptist Church for invasion of privacy and for the intentional infliction of emotional distress. A jury in federal court awarded Albert Snyder $10 million. The United States Supreme Court, in an 8-1 decision, ruled in favor of the members of the Westboro Baptist Church. The Supreme Court said, we don't have a right to privacy when we're out in public. And the court said there can't be liability for intentional infliction of emotional distress for speech that's protected by the First Amendment. Chief Justice Roberts, writing for 8 justices, was explicit in saying, speech can never be punished, speech can never be held liable simply on the grounds that it's offensive. Well, this brings me to my second point, and that is that freedom of speech is not absolute. There are categories of speech that are unprotected or less protected by the First Amendment. We're all familiar with the famous adage from the late Justice Oliver Wendell Holmes that there's no right to falsely shout fire in a crowded theater. It's a reminder to us that even though free speech is protected, there are limits. Let me mention 3 limits that seem particularly important with regard to college campuses. One is incitement of illegal activity. Speech that incites unlawful activity can be punished, can be the basis for liability. But it's important to separate the legal test for when speech can be punished incitement from the colloquial use of the word incitement. The legal test comes from a Supreme Court case in 1969 Brandenburg versus Ohio. There was a prosecution of the Klan, and the Supreme Court ruled in favor of the members of the Klan. And the court said, and remains the law to this day, that speech can be punished as incitement only if there is a likelihood of imminent illegal activity, and only if the speech is directed at causing imminent illegal activity. Example, imagine there was an angry crowd on a campus, and a speaker exhorted the crowd to go commit acts of violence, to commit arson, to commit vandalism, and it happened. I think the speaker in that instance could be punished for incitement. In fact, even if it didn't happen, if the speech met the standard I articulated, it could be punished as incitement of illegal activity. A second category of unprotected speech are what are called true threats. The Supreme Court first said in 1969 that true threats are speech that's not protected by the First Amendment. Courts repeated that on many other occasions. But it wasn't until June 27th of this year, in Counterman versus Colorado, that the Supreme Court provided us a legal definition of what's a true threat. The case involved a man in Colorado, Billy Ray Counterman. He became obsessed with a musician. She's referred to in the litigation by initials as CW. He sent her hundreds of social media posts over a couple-year period. Some were just describing his day. Over time, they became increasingly aggressive. She never answered any of them. She felt threatened. She canceled some concerts. She took security precautions. She then went to the police. Counterman was prosecuted under Colorado law that made it a crime to make a threat. He was convicted and sentenced to 4.5 years in prison. And the question before the United States Supreme Court is, when does speech amount to a threat? Justice Kagan wrote the opinion for the court. She said, the question is, was the speaker reckless as to whether or not the words will be regarded as a threat? She said, and it's now the legal standard, that someone can be punished for a threat if there's, quote, a conscious disregard of a substantial risk that the speech regarded as a threat of violence. Is there a conscious disregard of a substantial risk that the speech regarded as a threat of violence? If so, it can be punished. Third category of speech that's unprotected by the First Amendment, it's important on campus, is harassment. It's interesting that unlike the first two categories, there's much less from the Supreme Court telling us when can harassment be punished consistent with the First Amendment. There are federal and state laws that prohibit harassment based on race or sex. The easiest example, imagine that an employer would say to an employee, sleep with me, you're fired. And the employee would sue for sexual harassment. The employer would not have a viable First Amendment defense. Even though it was just speech, it's clear the employer could be held liable. There are a lot of cases in the employment context that say that it's harassment if it's directed at someone or if it's sufficiently pervasive to materially interfere with employment on the basis of race, sex, religion, sexual orientation. And courts have adopted the same standard with regard to schools, that it is harassment. It's not speech protected by the First Amendment if it's directed at somebody or sufficiently pervasive to materially interfere with educational opportunities based on race, sex, religion, sexual orientation. There's an awful incident at a university where someone painted a swastika on the door of a dormitory room occupied by a Jewish student. That would be regarded as harassment and not protected by the First Amendment. I was involved a few years ago as a lawyer in a case that involved harassment in the First Amendment. It involved Mary Washington University in Virginia. It's a public school. There was a debate on campus as to whether to have Greek life, fraternities and sororities. 3 women jointly wrote an op-ed in the campus newspaper opposing Greek life. They said that when there's Greek life in fraternities, there's more sexual violence against women. They then got targeted over a social media platform, Yik Yak, and over 600 quite ugly social media posts were written about them. Some of them threatened them with rape and murder. They went to the campus, and the campus said, there's nothing we can do. It's anonymous speech over social media. The campus said, we'll create a sharing circle for you. And the campus posted on its website that it wasn't responsible for anonymous speech over social media. The women, through the organization, the Feminist Majority Foundation, sued. The federal trial court ruled in favor of the university. It said it's anonymous speech over social media. I represented the women in the Court of Appeals, and we won. The Court of Appeals made clear that when speech constitutes harassment, universities cannot be deliberately indifferent to that. Now, there are many things the university could have done here without regard to suppressing the speech. It certainly could have provided protection for the students. Campus officials could have issued their own statements. Once the speech rose to the level of a threat of rape and murder, then the obligation of the campus also was greater, and there was more the campus should have done and could have done. But this case shows that when speech rises to the level of harassment, it's not protected by the First Amendment. There's no clear definition of when speech becomes harassment. There's no bright line anymore there is with true threats or incitement. But these are categories of speech unprotected by the First Amendment. You'll notice what I didn't list as a category of unprotected speech, and that's hate speech. I am regularly asked, as recently as yesterday afternoon, where is the line drawn between free speech and hate speech? And that question draws a false distinction, because generally hate speech is protected under the First Amendment. Again, I can tell you the leading Supreme Court cases. There was RAV versus City of St. Paul back in 1992. St. Paul, Minnesota adopted an ordinance prohibiting burning a cross or painting a swastika in a manner likely to anger, alarm, or cause resentment. Burning a cross, painting a swastika are ugly symbols of hate. Nonetheless, the Supreme Court unanimously declared the St. Paul Ordinance unconstitutional. The Supreme Court made it clear that hate speech is generally protected by the First Amendment. A decade later, in 2003, the court decided Virginia versus Black. This involved a Virginia law that prohibited cross burning. And the Supreme Court, in an 8-1 decision, said that cross burning, though vile, though a symbol of hate, is generally protected by the First Amendment. There were two companion cases that came to the Supreme Court together. One involved a Klan rally on an isolated farm, and a cross was burned. The other involved two men who burned a cross on the lawn of a family's home recently purchased by an African-American family. The Supreme Court said the Klan couldn't be punished for burning the cross. There were no onlookers. No one would feel threatened. But the men who burned the cross on the lawn of a home purchased by the African-American family could be punished because there was a threat. The point the court made was that speech can't be punished just because it's hateful. In the early 1990s, over 360 colleges and universities adopted so-called hate speech codes. Everyone to come to a court, without exception, was declared unconstitutional. Why is it that hate speech is generally protected by the First Amendment? Most European countries have laws that prohibit hate speech. Why not the United States? Some of it is the difficulty of drawing a law prohibiting hate speech that's not unconstitutionally vague or overbroad. Any law regulating speech in the United States must be specific about what's prohibited and what's allowed, and it cannot regulate substantially more speech than it needs to accomplish its purpose. Most of the hate speech codes that were struck down were invalidated on the grounds of vagueness and overbreadth. Example, after a series of ugly incidents, the University of Michigan adopted a hate speech code. It prohibited, as do many European laws, disparaging or creating a stereotype about individuals on the basis of race, sex, religion, sexual orientation. A sociobiology student brought a challenge us and said, a lot of my research is about whether or not there are inherent differences between men and women. I worry that my work is going to be regarded as stigmatizes or demeaning on the basis of sex in violation of the law. The federal district court found that the words in the law, the hate speech code, that prohibited stigmatizes or demeaning on the basis of sex were unconstitutionally vague. Several years ago, I taught an undergraduate seminar on free speech on campus, and one of the exercises was to ask the students to try to draft a hate speech code that wasn't unconstitutionally vague and overbroad. The students found that, as did campuses, quite elusive. I think also when we talk about hate speech codes on campus, we have to face the reality that often such laws are used against the very people who we seek to protect. Before the University of Michigan hate speech code was struck down, every disciplinary action under it was brought against Black students or Latinx students. When England adopted its first hate speech law, the first prosecution was saying that Zionism should be regarded as a form of racism and prosecuted those individuals. But most of all, hate speech is protected in the United States because it's seen to express an idea, a viewpoint. It's an awful, a vile idea and viewpoint. But remember, the core of the First Amendment is that all ideas and views can be expressed, even very offensive ones. The third point that I wanted to make was that there can be time, place, manner restrictions with regard to speech, so long as they leave adequate alternative places for communication, and so long as they serve an important government purpose. Even when there's a right to speak, it doesn't mean that there's a right to speak any place at any time. There's generally a right to use sidewalks and parks and streets for speech, but it doesn't mean there's a right to have a rally down the middle of the freeway at rush hour. And so that's why the Supreme Court has said, when it comes to using government property for speech, there can be restrictions with regard to time, place, manner, but they have to leave adequate alternative places for communication. They have to serve an important purpose. Examples in this context. Campuses can prohibit demonstrations outside of classroom buildings while classes are in session. Universities can prohibit demonstrations outside of dormitories between hours when people will be studying and sleeping. These are time, place, manner restrictions. They serve important purpose of letting the campus function, but they also leave adequate alternative places for communication. An example involving my own campus, Berkeley. Several years ago, there are going to be a number of controversial speakers coming on campus, and the campus made the choice to have the most controversial speakers be in an auditorium rather than the open area of the campus. The advantage of being in an auditorium is it's possible to secure the perimeter, possible to check IDs, needed to have metal detectors. It's out in the open area of the campus, not possible. The conservative speaker, Ben Shapiro, wanted to come to campus and wanted to speak in a large public area in the middle of the day. The campus said, you can speak. We'll let you speak in our largest auditorium on campus, Zellerbach Hall, and you get to speak at 7 o'clock because it's in use for the rest of the day for classes. He and his supporters sued and said that they should have the right to come onto campus to the public area and speak whenever they want. The university won because it was a time, place, and manner restriction. It gave him an adequate alternative place for communication. It was right on campus. It was the largest auditorium, and it certainly served the important purpose of safety on campus. I think a very difficult issue that campuses are facing now is how much do they have to spend in order to protect safety? At what point can they say, it's just too expensive, we can't assure safety, so we're not allowed the speaker? This too arose at Berkeley in the fall of 2017. A campus group, the Student Patriots, as they called themselves, were going to have Free Speech Week. And they had invited Ben Shapiro and Milo Yiannopoulos and Ann Coulter and Charles Murray to all come speak. Not all actually came. and it was going to cost a great deal of money for security. The campus decided to bear the cost, and it spent $4.5 million that week for security. But what if it wasn't Free Speech Week? What if it was Free Speech Semester? What if instead of it being $4.5 million, it was $50 million? At some point, the campus is going to say, all of this money is coming from our educational activities, and therefore we can't spend the money, and so we're not going to be able to provide safety, so we're not going to allow the speaker. Where is that line to be drawn? No court has yet answered that question. Is the line to be drawn relative to the campus budget, relative to the University of California budget, relative to the budget of the state of California? Where and how is that line to be drawn? I think that's one of the hard issues that's still to be litigated with regard to the First Amendment. My fourth and final point is that campuses can encourage responsible communication. There's an enormous difference between prohibiting speech and then punishing it, as opposed to encouraging conversation that's constructive and that's beneficial for all. For all, we're educational institutions. Dialogue is inherent to what we are. I think that campuses also have the obligation to create an inclusive learning environment for all students. The reality is that speech is protected because it has effects. The effects can be positive, but they can also be very negative. Hate speech perpetuates exclusion from campus of groups that have traditionally been marginalized. Hateful speech causes tremendous psychic and even physical harms to people. And so even though there's a right to say something, that doesn't necessarily mean it should be said. And I think it's important for campuses to remind students that even when there's a First Amendment right, our hope and our expectation is that students will speak with civility to one another. In the context of, say, a law school, that they will behave in a professional way. And I think that campuses have the obligation to take steps to create an inclusive environment. This includes, while students have their free speech rights, so do campus officials have speech rights. And there are times when I need to speak out. We had a terrible incident about 6 years ago in my law school. We had a prominent Jewish speaker, Alan Dershowitz, and someone drew a swastika over him. I immediately sent a message to the entire community explaining why that's inconsistent with our values and why it's not acceptable. I don't know who drew it, could punish anybody, but I could certainly express our values. More recently, I've heard in my law school and on campus anti-Semitic and Islamophobic speech. I wrote an op-ed in the Los Angeles Times a week ago that decried such expressions of racism and bias. So my students have the right to speak, but so do I have the right to speak. And at times I think I have the duty to speak. Well, these are some of the basic principles with regard to free speech. Let me simply say, I realize that there are those who disagree. There are those who think we provide too much protection for free speech, that we don't provide enough protection against the harms of speech. And I understand that position, but I always worry that the only way that my speech can be safe tomorrow is to protect the speech that I don't like today. All of us would naturally allow the speech we like to go on. What freedom of speech is important is to protect the speech that we don't like. For me, the core reason for protecting freedom of speech is a distrust of government. I have a distrust of government at all levels, whether they're talking about the president or the governors or presidents of universities or deans. And I don't want them to be able to decide what speech we can hear and what speech we can't hear. I'm much more of the view that we should let all of the ideas and views be expressed rather than giving anyone the power to make choices for us about what we can hear and what we can see. Ultimately, the First Amendment is based on a faith. And the faith is that we are better off letting all ideas and views be expressed than we are to give any government officials the power to choose for us the ideas and views we can hear. I believe that faith, though certainly sometimes I question it. Thank you so much. I think I've used my time, and now I'm available for your questions.
Erwin, thank you. You laid out some really important points that we should all remember about why the First Amendment is there, as unpleasant as it might be in some moments. Let me ask the first question. There are some themes that I'm seeing in the Q&A. Yes, we need to allow free speech. We've just recognized that that's necessary. And yet, what is the responsibility of a higher education institution to create safety and sort of lack of excessive emotional distress for students when they are exposed to hate speech that cannot be censored? So yes, we want to allow the freedom of speech, but what about the impact on those on the other end and their learning experience and the thing that they came to do at the university?
I want to draw a distinction between physical safety of our students and the emotional safety of our students. I think we have the obligation, legally and morally, to protect the physical safety of our students. Just in my law school in the last 6 weeks, we've taken significant steps to increase physical safety. But I don't think that a campus should try to endeavor to protect the emotional safety of students, to protect students from being exposed to things that might upset them. It's the nature of an education that will often be exposed to things that will upset them. And I'm constantly hearing from my students the phrase, I feel unsafe. And what I try to do is say, tell me why you feel unsafe and tell me what it is that you need us to do. If it's physical safety, I want to do what we can. If it's about emotional safety, there I've got to say, we can't protect you from the things that offend you. Now, there are things that we can do, though, which I want to be clear, I do care about the emotional safety of my students. So, for example, we provide, as I know your university does, counseling services to students so that we can provide mental health support for the students. We provide safe spaces for students to go to where they can be with those who are experiencing the same thing. I imagine that your campus, like ours, has things like a Black student union or a Latinx student union. Is that kind of physical safe space, or student organizations, even if it's not a physical one, where students can get together with those who are experiencing the same thing. We certainly can speak out ourselves as administrators. What I found is that when administrators speak out to condemn offensive speech, there's a tremendous benefit to that. I remember many years ago when I was professor at the University of Southern California, someone wrote a homophobic slur on a board where an openly gay teacher had just been instructing. And what the dean did in response was put a letter in every mailbox. This was before there was the internet, condemning that and explaining why it was inconsistent with the community. And I thought it was tremendously beneficial, and probably even more beneficial than we're going to try to figure out who wrote it and what to do about it. So yes, we should care very much about the emotional safety of the students, but it can't lead us to suppress messages just because they're offensive or even hateful.
So here's a question about when, as an administrator, do you choose to make a public statement? What factors into that decision to make a public statement about something or not?
I think that is an enormously difficult question, and one I spend a great deal of time thinking about, because I can't speak out against everything. And I realize that the more I speak, the less anyone pays attention to what I have to say. So I need to think carefully about what to say. And my bottom line answer to your question is, I speak out when my silence would be a message that I don't want to have. So as an example, after the tragic death of George Floyd, to not speak out at that moment would have been the wrong message. After January 6th, to not speak out would have been the wrong message. And so I'm always thinking about, as an administrator, where will my message help our community? And people at times do want administrators to voice their pain, to express empathy and compassion, and also to condemn hateful speech. So as soon as I learned of a swastika that had been painted on a poster, I immediately felt the need to speak out as against that. I've felt the need to speak out in other instances, but ultimately my question is, what message would be conveyed by remaining silent? And is that the message I want to express?
So here's a question from who I suspect might be a student leader. Given today's increasingly polarized climate, do you have any advice on how student leaders can support and promote an environment that respects free speech and also ensures the safety and inclusion of all students?
A great question. I think it's so important that campuses provide forums where ideas can be exchanged and discussed. Sometimes it's simply having speakers from different viewpoints at varying points in time speak. And so I think now I probably wouldn't create a forum where I brought onto the same stage those who are taking the varying positions where I was going to the Middle East, but I want some speakers to come and talk about the Palestinians' perspective, the Israeli perspective, the historical perspective. And at other times, I'd want panels to bring them all together. So to go to the specific question, I think that student organizations can bring in speakers of varying views. They can create panels of varying views. And also, I would hope that student organizations like administrators would say, we want to be a campus where all ideas and views can be expressed. And if nothing else, we want to treat each other with respect and tolerance. I always say to the students, say they'll go to the Middle East, we're not going to solve the problems of the Middle East in the Berkeley Law School or on the Berkeley campus or on your campus, but we can control how we treat one another. And I would hope that even when we disagree, we can treat one another with respect and tolerance.
Yes, lots that we can all do, including our student leaders, to promote the kind of environments we need. Question here about whose understanding counts in understanding a true threat. Does explicitly advocating genocide constitute a true threat anywhere or everywhere? Does implicitly advocating genocide count? Does it matter if the threatened group has in fact experienced genocide?
It's a great question. I'm going to give the general answer and then move to the specifics. Advocating genocide is really vile speech, but it's generally protected by the First Amendment. And so people have the right to express very hateful things, as awful as it is, and advocating genocide is that. On the other hand, at the point at which it's directed at somebody, then it's no longer protected speech. So if somebody were to say to me or send an email to my Jewish students, I believe that we should go about finishing what Hitler started, where I'm sure people have heard about the horrible incident at Cornell about 10 days ago, where students said he was going to go to the kosher dining hall and he was going to kill people. That's a true threat. And so we have to draw the distinction between advocacy of an idea, even a very vile idea, versus speech that would be shown to be likely perceived as a threat of violence against a particular person. So if you want an oversimplification, when it's directed at a person or a group of people who are identifiable, and it would reasonably cause them to fear for their safety, I think we're now in the realm of true threat. But expressing an ideological position, albeit a deeply offensive one, it's not going to be regarded as a true threat.
That is an important distinction. There's a question here from a faculty member, and I think this question, reverberates with many of us. I find myself self-censoring during my classes. Indeed, I lecture more than I used to in order to prevent class discussions from going off the rails. I fear students will complain about viewpoints that are expressed in class when we cover controversial topics. Would the First Amendment protect me from legal or campus disciplinary actions if I decide to stop a debate that is becoming too heated?
Let me talk first about the issue of self-censorship and then answer the specific question. We all engage in self-censorship all the time. From a young age, we're taught there are certain things that you shouldn't say to other people or say in public. So the idea of self-censorship isn't inherently a bad one. On the other hand, I think on campuses now, both faculty and students are refraining from expressing ideas that should be part of the discourse. I worry within the context of my law school, not about the school administration punishing speech, we don't do that, but students, because of social pressure, not expressing certain ideas, so they don't become part of the discourse. And in that sense, I worry we're really losing something on campuses. Professors, in answer to the specific question, have broad latitude in how to conduct their classes. It's not unlimited latitude. If I assign a professor to teach contract law, and the professor protests and says, I'm never talking about contract law, I'm just going to talk about sports and entertainment all semester, I could discipline that professor because it's not doing the job. But how long to let a debate go on, how to structure the debate, when to cut it off, all of that is very much protected by the faculty members' academic freedom. So in answer to the specific question, I think that faculty members very much could cut off a debate if they think it's not being constructive or just for a matter of time. I this morning had a lot of students who wanted to continue to participate, but I needed to move on at some point. I thought the main viewpoints had been expressed. So academic freedom matters in terms of what we write and how we teach as faculty. It's just not unlimited.
Can you explain a little bit more about the difference between free speech on campus and academic freedom? There are a couple of questions on that topic.
If Venn diagrams are useful, you can think of this as overlapping circles. There's things that are protected as a matter of free speech that aren't protected by academic freedom. There's things that are protected by academic freedom that probably wouldn't be protected as free speech. And there's some things that are protected by both. Academic freedom is the freedom for faculty to, in their scholarship and teaching, express their ideas and views without facing adverse consequences. Now, how does this relate to free speech? To start with, free speech applies only to government institutions. Private institutions do not have to comply with the First Amendment. Now, there may be within private institutions other things that create a commitment to free speech. Faculty and student handbooks might do that. But keep in mind that the First Amendment, like all constitutional rights, limits only what the government can do, not private institutions. But academic freedom provides safeguards for faculty in both private and public universities. There are other differences. If a faculty member were to be disciplined for a scholarly article, that would violate academic freedom. But academic freedom doesn't protect what the faculty member does, saying going to a Klan rally on the weekend, if they're going to participate in the Klan rally. That's not academic freedom. The First Amendment would protect the ability of the faculty member to go there, but it can't be said to be a part of academic freedom. So that's why I say, think of it as a Venn diagram. There's some things protected by the First Amendment, but not by academic freedom. Going to the Klan rally or the Nazi rally on the weekend. And there's some things that are protected by academic freedom that wouldn't be protected by the First Amendment. Think of this in private college universities. But then there's some that are protected by both. The articles and the books that I write are certainly protected by both the First Amendment as a public university and by academic freedom.
That's really helpful. I appreciate the Venn diagram imagery for us to hold on to here. There are several questions and comments about the cancel culture. And one in specific says, should we cancel culture? What are your thoughts?
As always, definition matters. And I'm not exactly sure what that person or those questioners had in mind with cancel culture. Let me try to address this directly. There is no First Amendment right to use speech to silence others. So there was an incident at Stanford Law School just last March where a conservative federal judge was coming to speak, was invited by a conservative group, the Federalist Societies, and students disrupted it so that the person couldn't be heard. Those students had no right, assuming it was a public university or the rules of the First Amendment apply, to use their speech to silence someone else. There was an incident at the University of California, Irvine, about 13 years ago, where the Israeli ambassador, Michael Oren, was coming to speak, large auditorium. And as he stood up and began speaking, a student rose in the audience and yelled so Oren couldn't be heard. That student was escorted away. Then a second student did this. Ultimately, 11 students did this. And the argument was, well, they were just exercising their free speech by shouting him down. Free speech doesn't protect a right to do this. There's even a name for it. It's called the heckler's veto. We don't allow a heckler's veto. Otherwise, the only speech that would occur is that which no one cares enough to shout down. And so I send out an announcement, a letter to all of the students and faculty and staff in the school at the beginning of each year, reminding everyone of our free speech principles, many of which I've described today. But it also says there's no First Amendment right to use your speech, disrupt an event, or silence others. And if you do that, you will face discipline. If you don't like a speaker, have a non-disruptive protest. If you don't like a speaker, invite your own. But you can't engage in canceling by speaking in a way that others can't be heard. Now, I want to draw a distinction between that and social pressure. That it's certainly the case that if somebody says something offensive, then the response to it can be, I found what you said really offensive, and would say, well, but that's cancel culture. No, I don't think that's cancel culture. People have the right to speak and say offensive things, but others have the right to say, what you said was really offensive to me.
So as you know, as an academic leader on campus, so what are your thoughts about how we might educate our students on what's permissible, what's not, the best ways to think about all of this? There's a lot of language that is being used across our community and all communities. What's the best way to educate our students, from a leadership standpoint of the university, from faculty and staff that are engaging students, our student leaders and other influential students? How do we take this on from an education standpoint? What's okay, what's not okay? How might, we go about doing this the right way?
I think what's key is there's no one thing that a campus can do to achieve what you're talking about. It has to be many different things. And my hope is that students, before they ever get to university, when they're in elementary and high school, will have begun to learn about free speech principles. But I also know that we can't assume that to be true in the context of a college, university, or even a law school. I'll tell an anecdote and then I'll answer your question directly. We had a very conservative speaker come in at the law school about 2 months ago. And some students were really upset and felt that what she said was hateful. It wasn't disrupted. And the co-presidents of student government, one of them was in my First Amendment class this semester, said to me, you have to prevent such hateful speakers from coming here. It really upset a lot of students. And I said, but because of the First Amendment, we can't exclude speakers. And what she said was certainly controversial. None of it would rise to the level that we think of hate speech. There was no epithets or anything that used. And I realized that even though these were law students, and one of them studying First Amendment this semester, there was still this natural impulse of silence the speakers we don't like. So now I can get to your question. I think it's so important that campus administrators, presidents, deans articulate the values of the community with regard to speech. And we look for opportunities to do that. It just can't be one statement at the beginning of the year. I think it's important that campuses put on programs like this lecture series you're doing as a way of having discussion of free speech. I'm sure on your campus, like on mine, there are classes that are offered that look at free speech there. I think having special programs for student leaders, so when they put on events, they know the free speech principles are there. But these are just examples. The most important thing is no campus can believe it can do one thing and then imbue free speech there. It has to be many things every year and over years.
Or when you talked about hoping that students coming into universities are exposed to some of these ideas early in their school experience, there's a question here that asks, can you give us your thoughts about the right of public school-aged children to receive information in light of some of the current book banning legislation and laws?
It's an enormously difficult question. And again, I can tell an anecdote of a case that I was involved in that came from Arizona. The Arizona legislature adopted a law prohibiting the teaching of ethnic studies. It was particularly applied in Tucson to stop Mexican American studies classes from being taught. And the trial court dismissed the challenge to that law in Arizona, prohibiting teaching ethnic studies. And I argued the case in the Federal Court of Appeals, and I won, with the Federal Court of Appeals finding the Arizona law and then the district court finding the Arizona law to be unconstitutional. Here's the problem. Public schools have a great deal of latitude in setting their curriculum. Also, public school libraries have latitude in deciding what books to buy or not buy. No public school library can purchase every book that's there, and they're going to buy some and not buy others. They're going to allow some on the shelves and not others. If what the public school said is, we're not buying any Nazi or Aryan brother literature, no one would object. But if the school library said that what we're going to do is only have authors who support Donald Trump or support Joe Biden, we would all say that that's objectionable. So what's difficult about this is schools do have latitude to set their curriculum. Libraries do have latitude to decide what books to put there, but it's not unlimited. Where is the limit? The leading Supreme Court case was one called Island Tree Board of Education versus Pico, and it stressed the right of students to receive information. And it involved removing books from a library. And it said, well, the library can choose not to buy the books and remove them if they're vulgar, but they can't remove them just based on ideas. That's too simplistic, because I think the library could choose not to have white supremacist literature in its books, but it can't say we're going to only allow Democratic or Republican ideas. All of which is to say, the law is very unclear with regard to how that line is to be drawn. But it's so important now. To give examples, many states have adopted laws teaching of critical race theory. Some states have adopted more restrictive laws with regard to what books can be in the library. And all of this is being challenged. And you've got the tension between, on the one hand, the school's ability to set its curriculum and what's in the library, versus on the other, the right to receive information and knowing there has to be a limit on what states can do.
Complicated issues. There's a follow-up question on the example you cited about, bringing or giving platform on campus to, perpetrators of violence or, other people with, reputable histories. And how do we balance that with the values of the institution? I mean, one of the remedies here that you're suggesting is universities speak from their value system. But if you're obligated to give platforms to people who sort of are counter to your value system, how do we reconcile that?
I think the key is who's issuing the invitation. I, as dean, invite a certain number of speakers a year. I don't invite those speakers randomly. I try to make sure I'm inviting both conservative and liberal speakers. But then there's the ability of a student organization to choose what speakers to invite. And student organizations have the latitude to decide what views they want to express and not express. Now, campuses can have rules in terms of how much notice needs to be given, how rooms are reserved, and things like that. But I don't think a campus can generally say to a student organization, you can't have this speaker or that speaker because that speaker is too controversial, or this speaker will upset people. Now, if it's a speaker where there's been incitement to violence in the past, then it becomes a more difficult question, but it goes to the test for what's incitement. But generally within latitude, student organizations have discretion to decide what speakers to invite and what viewpoints to be there. And the campus can only enforce general content neutral rules. The campus generally can't exclude speakers just because it doesn't like a viewpoint.
Mhm. So an important group of students on campus who've been in the news for a variety of reasons are campus journalists. What are some ways that college campuses can continue to ensure free speech for journalists?
To begin with, and consistent with what we've been saying, I think it's so important that campuses provide education for journalists about the First Amendment and also about the limits on free speech and free press. When I was talking about incitement and true threats and harassment, was speaking generally to campus. But of course, when it comes to journalism, then we get into some other issues. Defamation, for example, is very important in that regard. Invasion of privacy is important in that regard. And so I think it's important that campuses have either that they provide or through other organizations, education for journalists. I think campuses need to stand behind the free press and free speech rights of journalists. The nature of journalism is it's often going to be focused on those who are in positions of power, and it's often going to be uncomfortable what the student newspapers say about the campus president or chancellor or deans, and that's just part of journalism. And I think that campus leaders need to stand up for the right of the newspapers to exercise their right to free speech. There are laws that protect campus newspapers, like all newspapers. There's, for example, a law that limits the ability of the police to go and search newsrooms. It arose as a result of a police search of a campus newspaper at Stanford. The case is called Stanford Daily versus Zurcher. And Congress passed a statute that very much limits the ability of police to search newsrooms. It's not never, if there's reason to believe there's evidence of a crime in a newsroom, they can be searched like anyplace else, but it's a much more restrictive standard for that. But I think the most important thing for campuses to do is educate student journalists with regard to what's permissible and what's impermissible, what their First Amendment rights are, and where there are limits.
I'd like to pivot to a broader topic here. We all agree that the First Amendment is critical to democracy and the kind of democracy we talk about in this country. Now, here's a question that says, sometimes the enemies of democracy use the freedoms that democracy provides us with to dismantle it. How do we think of this conundrum?
It's a great question. It's one that I talk about a lot in my First Amendment class. Should, for example, free speech protect the right to advocate the overthrow of the government? If what we care about is tolerance, then why should we have to tolerate intolerant speech? And I think the answer that's emerged over time is that we don't want the government to be able to protect itself by censoring the speech that would criticize it or even might advocate its overthrow. I mentioned to you the test now is that speech can be punished as incitement, including incitement of overthrow of the government, only if there's a likelihood of imminent illegal activity and all of the speech is directed at causing an imminent illegal activity. In the early 1950s, in the McCarthy era, there were major efforts to punish people just for advocating communism or joining organizations that were communist, or even be thought to joining organizations that were communist. In an important case, Dennis versus the United States in the early 1950s, Justice Black and Douglas in dissenting opinions talked about how democracy is strong, and if it can't be saved, stopping the speech that advocates communism isn't going to be the way to protect it. The same thing with regard to intolerant speech. We have to be tolerant, if we're going to tolerate, even of intolerant speech. And I think here that the best remedy for the speech we don't like is more speech. Is there a risk? Is there a danger that speech that advocates the overthrow of the government could mean the end of democracy? Is there a danger that intolerant speech, hateful speech, can lead to hate crimes? Yes, there's that danger, but it's thought, I think, better to let the speech be expressed than to give government the power to decide what we can and can't hear.
I'm going to pivot to sort of the campus responsibilities and the way campuses have to react to some of these situations. So there's a question that is connecting the example you cited about social media harassment of the three women. When does the university have the moral obligation to protect its students? Excuse me. And the question says, how might we understand moral obligation in a legal rather than a strictly ethical framework?
I do think it's important to distinguish the legal obligation from the moral obligation. I'll go back to the idea of Venn diagrams. There's some places where I'd say there's a legal obligation to do something. I don't think it's particularly a moral obligation to do it. I'm legally required to pay taxes. I pay them because I don't want to go to prison. I'm not sure I'd regard that as a moral obligation. Maybe someone would argue it is. On the other hand, there are places where there's a moral obligation, but no legal obligation. And we can certainly think of, I morally want to treat everybody who I meet with as much kindness and respect as I can. That's not a legal obligation. But then there's places where our moral and our legal obligation overlap. I think with regard to safety of our students, there's both a legal obligation and a moral obligation to protect their physical safety. In terms of the context of the case that I described, the legal obligation, Title VI of the Civil Rights Act of 1964 says recipients of federal funds can't discriminate based on race. Title IX says recipients of federal funds can't discriminate on the basis of sex. The Supreme Court has said that a harassment on the basis of race and harassment on the basis of sex violate Title VI and Title IX, respectively. And the Supreme Court has said that the legal standard is, and I'm quoting the exact words, that there cannot be, quote, deliberate indifference with regard to race and sex discrimination, race and sex harassment. So the legal obligation comes where if you don't act, it would be regarded as deliberate indifference. But I have the moral obligation, even if there's not a legal obligation. So I have the moral obligation to support my students of color, even beyond the legal obligation. I have the moral obligation to provide mental health services to my students, even though, might not be said in most instances, I have the legal obligation to do so. But I do think it's important to keep separate when we're talking about legal, when we're talking about moral, and when it's something is a matter of both.
Mm-hmm. That was really hugely helpful to hear, Erwin. There is another question about how campuses respond to this. Can you discuss the role of disclaimers, removing the university's responsibility from hosting controversial speakers or organizations and their roles on campus? Are disclaimers positive or negative to the impact of the obligation of the university towards these guests and speakers being on campus?
You had asked me earlier, when do I want to speak out as an administrator? When do I think other administrators speak out? And my answer to you was, when my silence is itself a message, and a message that I don't want to convey. So there are instances where when there is a speaker or something occurs on campus, people may impute it to the administration. And there's a big difference between my supporting something that's said and my allowing it to be said, especially because the First Amendment requires it. There's all sorts of things, I'm sure, on your campus where the administration allows it because it's required to on the First Amendment, but doesn't endorse it. And the danger is that sometimes allowing it is taken as an inference that it's endorsed by the campus. And sometimes the campus needs to speak up, so its silence won't be a message. It needs to say, we're permitting this because the law requires us to, we're permitting this because academic freedom requires it, but we're not endorsing it. This isn't our speech. Let me give you a concrete example. I have a member of my faculty who wrote an op-ed in the Wall Street Journal about 3 weeks ago, saying that he believes that law firms should not hire our graduates who've expressed support for what Hamas did in Israel. That's a very controversial position. My response, and I sent a message to our entire law school community, that he speaks for himself, he doesn't speak for the law school, that we're committed to helping every one of our students get a job. It was so important to me that everyone realized that's not the law school's position. That's his position. And he has free speech rights. I disagree with what he said, disagree with how he said it, but he's got the right to say it. And so my answer is disclaimers are important in instances where people might wrongly conceive of something as coming from the administration when it's not from the administration, or from the university as an entity when it's not coming from the university as an entity.
There's a question here about your thoughts on the Chicago statement. And are there reasons why universities or faculty associations should adopt the statement or not adopt the statement? Your thoughts?
This goes to the Calvin report that was drafted by Harry Calvin, who was at the University of Chicago. And there's things in it that I agree with and things in it that I disagree with. And I'll focus on statements. The Calvin report seems to say that college and university administrators should not express views on matters, that they should be silent. And in the face of the Hamas attack on Israel and Israel's assault on Gaza, some campus administrators said they would say nothing. They were following the Calvin report. There I disagree, because there are times, as I've said to you, where silence is a message. And I feel the need to speak up so that my silence isn't a message. I think there are times when the community wants its president or its dean to be able to, as I said, express compassion and empathy, to articulate again the values of the community and the like. Now, there's another part of the Calvin report that I agree with. And my position is that I don't think that schools or departments, as schools or departments, should be taking positions. I think that it's absolutely for faculty individually or collectively, students individually or collectively, to take a position. And so, as an example, when the Supreme Court overruled Roe versus Wade, the president of the University of California issued a statement. A lot of our faculty signed statements, but I didn't think it was appropriate for the law school as a law school to issue a statement. The same thing with regard to the events that have gone on in the Middle East. I don't think the law school as a law school should be taking a position. I worry if it does, what about minority viewpoints? I worry also who really gets to speak for your university or my university. Ultimately, it's the regents of my university who get to take the position. So every individual, an administrator, a faculty member, a staff member, a student, gets to express their view. And they can join together in collective statements. But I don't think that the department as a department or the school as a school should be taking a view. And I realize that's controversial. And mine is a minority position here on the, I was on a committee on this campus where I had to write a dissent to express that. But that also goes to the Calvin report.
So this question about when administrators speak up and so on, there's another variant here. I don't know if you're aware or not, but a national organization recently listed faculty at our university and put them on a watch list because they disagreed with some of their perspectives. Now, the question here is, are there any legal implications for these organizations that create these watch lists of faculty, and sort of the consequences then to faculty? In our case, some of the faculty were threatened personally and so on. And then separate from the question, this was an instance in which Dr. Crow took a public stance and spoke against this, now speaking on behalf of the institution. So one, how do we address these kinds of scenarios where external organizations, create sort of distress to faculty and others? And then in this instance, our university and our president did take a stance. So how do we think about these kinds of external threats to the institution?
You don't need me to say it, but for what it's worth, I think Dr. Crow handled it perfectly. Now let me explain why. Organizations have the First Amendment right to engage in their speech. If they want to put together a watch list of professors who are too liberal or too conservative or too whatever, so long as they're not making false factual statements, and so long as they're not releasing private information, they have the right to do so. Now, if they were to, for example, say about certain professors that they engaged in forms of misconduct that they hadn't done, Well, that would be a false factual statement. That's defamation. That's not protected. If they release private information about people, imagine unlisted home phone numbers, social security numbers, that's not protected. But generally, that's not what these watch lists are doing. The watch lists are making their list however they can and expressing their opinion about those listed. I don't like them. I think that they chill speech. I think that they do lead to harassment. But so long as it's opinion, so long as there's no false factual statements, so long as there's no private information, they have the right to do that. On the other hand, campus administrators, I think, need to speak out against that and condemn them as inconsistent with our values. That's what Dr. Crow did, and that's what I think was so important there, because it is the chance to say that this does chill expression. We want to be a place where all ideas and views can be expressed, and to have these kind of watch lists does inherently inhibit what's said.
So the next question is, I'm posing this to you as an educator, somebody who is in the classroom. A lot of conversations between people, when they are particularly contentious, can end up in arguments or, worse. What is your advice for facilitating discussions or practices where people are able to express their freedom of speech, but without it degenerating into something that is unproductive?
Sure. Let me say several things. One is, I think it's important for a teacher, and I do this as a teacher, to articulate my values and views for the class at the very beginning. And so the very first day, I talk about, and do it much more now than I used to, how I want my classroom to be an idea where all views and ideas are expressed. And I want students to always be treating the views that they disagree with respect, and then they'll get their opportunity to speak. And I explain to the students why I think they are much better off hearing all viewpoints rather than silencing the ones they disagree with. In the context of law, they're going to have to answer the opposing arguments, so they should be able to hear them. And their education is impoverished if they shut down other ideas. But one thing I think that if it's a class where there's going to be controversial ideas expressed, at the beginning for the teacher to say, this is what we're doing in this class and how we're going to go about it. And I do it the first day of the semester because I teach things like constitutional law and First Amendment law and criminal procedure about policing. Second, when there's a controversial topic, I try to look for a way to structure it that will lead to a more constructive discussion. Let me make this concrete. I teach constitutional law, as I said, so I have to teach about the issue of abortion. And there's very deep emotions on both sides. So what I do is I say at the beginning, I can identify 5 different positions that the Supreme Court might have taken in Roe versus Wade and Dobbs versus Jackson was Health with regard to the issue of abortion. And I lay out the 5 different approaches, ranging from they could interpret the Constitution to say that fetuses are persons at the moment of conception and no law should be allowed permitting abortion, to saying that a woman or a pregnant person should be able to end the pregnancy at any. And I go through, I lay out the 5 options. And then I structured the discussion around asking the students to identify the arguments for and against each of the options, the implications of the options. And so what I find is by structuring the discussion that way, all the views come out, but they come out in a more constructive way. Teaching First Amendment law this semester, I mentioned. And so we spent a whole class on the issue of hate speech in the First Amendment. And I began by saying, I want to separate the description of the current law from the discussion of what should the law be. Let me tell you the current law, and then we can talk about what should be, and then try to structure the discussion in a way that would be a constructive rather than just a heated debate. And the students very much disagreed with one another. Third, if there's not opposing viewpoints that are expressed when it's a discussion, I will advance them. This morning in class, we were talking about Citizens United versus Federal Election Commission, and whether corporations should have the right to spend unlimited amounts of money in an election. All of the students were against that. So I found that what I was doing was presenting the counter arguments to make sure that they all came out. And fourth and finally, what I do is when discussion is inappropriate, either identify it as such or cut it off. If a student says something that's inappropriate, there's times when I'll say, that's an inappropriate comment. I try not to chastise students. It's a last resort. But I have had students say inappropriate things in my class. And again, my silence would be a message. And if I find that the discussion isn't going well, or it's just more heat than light, I then move on to the next topic, which goes to a question we had earlier.
Those were really good reminders for all of us educators on how we can actually use the spaces of our classrooms to not just have students engage in the conversation, but learn how to have some of these civil discourses on really complicated things. Here's another question for faculty members who are on the receiving end of some of, unpalatable free speech. So the question is, faculty and staff from the LGBTQ plus community have been targeted. And in our instance recently, citizen journalists have bombarded them outside of their classrooms. They have been aggressively accused of grooming students and making vile statements. What actions can faculty or staff take when they are sort of on the receiving end? In this instance, it's LGBTQ plus, but it could be any other group. What's appropriate here?
Sure. And again, I think there's going to be many things depending on context. First, if there is a physical threat, it's the responsibility of the campus and the campus police to provide security. And if ever my faculty feel physically threatened, we then alert campus security, and if necessary, even going to state and federal authorities. We have had an incident recently of a faculty member who received very threatening messages. And at that stage, we have to go outside of our school, the law school. We need to go to the campus security. Even we need to go to outside security. But I want to focus on physical threats needing to be dealt with in that way. Then there's email. There are ways of protecting people from email. There's filters that can be created for emails. There's ways that the campus can help people if they're being doxxed to take down things from the internet. And I'm sure your IT department, like ours, helps to provide protection in that way. There is the ability of campus officials to condemn the treatment of faculty in this way. So we've been talking a lot about when do campus officials speak out. If my gay and lesbian transgender faculty were targeted, I would certainly speak out as strongly as I could as against that. And I think it's really important in that situation that that group of faculty feel that the administration has their back and is going to do what it can to protect them consistent with the law. So when I've had situations like that, I obviously meet with the faculty and ask them, what can we do to help you? There's things we can't do, but there's certainly a lot of things that we can do. And if nothing else, I hope expressing support, conveying that we have their back will matter in itself.
So here is a question again relates to faculty. Can a public university dean refuse to assign a professor to teach a class because of the professor's hate speech outside of class?
Oh, that's a really hard question, and it's hard to answer in general. I believe that a tenured faculty member has his or her position unless cause is shown for demotion. But I don't believe that a tenured faculty member has a right to teach a particular class. So many things go into what faculty teach, which classes, including what other people are teaching, student demand, and the schedule. So a university, I think, can say, we want you to teach this class rather than this class. Sometimes my faculty are upset. I need someone to teach contracts. They may not be their first choice, but I can do that. Now, what about their hate speech? This isn't hypothetical in the sense that there was a University of Pennsylvania law professor, Amy Wax, and she said many hateful things that you can read about on internet and social media. And one of the things that the University of Pennsylvania Law School said is, we're not going to have you teach any required first-year classes. We're going to only have you teach upper-level classes, so the students who want to be in your class can choose, but because all of the hate speech it's going to make some students be uncomfortable in your class. I mean, she said things like that there'd never been a Black student in the top half of the class at the University of Pennsylvania Law School, which is a false statement. But at any rate, the university said, we're going to have you teach upper level classes, which are elective rather than required. I don't think that violated her First Amendment, private university, or her academic freedom, because I don't think you have a right to teach a particular class. So again, context and circumstances are going to matter a lot.
So here is a question from, I think this is a student. Can colleges restrict the use of profanity? We have a code of conduct policy which includes not using profanity in class, including writing assignments. Does this code of conduct violate students' free speech?
The leading Supreme Court case here is Cone versus California from 1971. It involved a boy in a courthouse with a jacket on his arm. And I apologize, I'm probably violating a code of conduct. I'm going to quote what's on the back of the jacket. It said, quote, "fuck the draft." And he got prosecuted and convicted. And the Supreme Court overturned his conviction. And very eloquent opinion, the Supreme Court said, to censor words is to censor ideas. We can't cleanse the English language to please the most squeamish among us. So in general, there is a First Amendment right to use profanity. And sometimes profanity is particularly powerful in conveying a message. Think of the words on the back of Cone's jacket. What other three words would have so conveyed his views about the draft? Transgressive language is very powerful precisely because it's transgressive. Now, I think that's different than the part of the question about what's in a paper. I certainly can set standards of academic quality for the papers that I receive. And if the paper doesn't meet my standards of academic quality, it's going to get a low grade. And I would think that for a paper with regard to academic quality, I would generally regard profanity as an indication of a lack of academic quality. On the other hand, if they're writing about Cone versus California, I'd expect that they would quote the profanity. Within campus, I think if the campus tried to punish a student just for using a profanity, just for that, I think the student would win on First Amendment grounds. That's different than the papers, and a lot depends on context. You know, if somebody were to use a profanity and call it out to, imagine a profanity that's used about women and call that out to a woman on campus, in that kind of harassment, that would be different than just, I'm talking to somebody in a conversation and somebody overhears it and I used a profanity. I am sure that your campus is no different than mine. Profanities are used in conversation, but that doesn't mean that they can always be used or be used in academic papers.
That's helpful. There's a question that is not related to campuses, but trying to unpack really where free speech plays out. Why isn't Julian Assange protected by free speech or journalistic freedom?
It's a great question, and of course, it's never been adjudicated. There are federal laws that prohibit the disclosure of confidential information and the publishing of confidential information. So Chelsea Manning took confidential information and gave them to Julian Assange, who then published them over WikiLeaks. I don't think that Chelsea Manning could say, I have a First Amendment right to take confidential information from the government and give it to somebody else. On the other hand, I think in terms of publishing that information, it's a much harder question. Think of, maybe most of the audience doesn't remember, one of the most famous Supreme Court cases was New York Times versus United States in 1971, when the New York Times and the Washington Post got access to the Pentagon Papers, a classified history of the Vietnam War, and they published it. And the question was that protected by the First Amendment? And the Supreme Court ruled in favor of the New York Times and the Washington Post. So whether Julian Assange fits into that category or would be punished, that's harder. Imagine that I came up with a list somehow of where all of our secret agents are located and their names and addresses in Europe, and I published it. I would do enormous harm to the government, or I learned where our missile silos were. and I published it, or the United States was going to launch a secret defense and I published it, I could be punished for that. So is Julian Assange equivalent to that? Or is Julian Assange much more equivalent to the New York Times and the Washington Post? That's the underlying issue.
That is helpful clarification. As we're rounding up, I know we have just a couple of minutes left. What are your thoughts about, you discussed, really helpfully what instructors can do in the classroom environment. What are your thoughts about how universities and colleges can allow for difficult discourse to take place in public forums? And the question here is, you have one group speaking at one event, another group speaking at another event, and that's sort of how it is happening right now. How might we allow for and support public discourse on our campuses to really advance thinking, critical thinking, and important ideas?
That is public discourse on campus. And so if you have on a particular issue, speakers on one view at one point and speakers another viewpoint, that is public discourse. It may not be the best form of public discourse on a particular issue, or it might be the best form of public discourse on an issue. Here's what I mean to make it concrete. At this moment in time, I think when it comes to what's going on in the Middle East, it's better to have speakers who take one position separate from speakers who do another position. I would not want to create a forum where I'd bring together the varying viewpoints. Might I a year from now? Absolutely. And so in some topics, it's great for universities to bring together all at once competing viewpoints. At some points, it may be better for universities to have the different viewpoints expressed separately. So much depends on context. But to answer the specific question, I think what universities do is provide opportunities for all of the views to come out over a period of time and to support student organizations and departments when they bring in speakers, for the university administration to bring in speakers. And sometimes there'll be, as I say, forums where we have a lot of different views on the same subject expressed, and sometimes better to the different viewpoints expressed separately. It just depends on the issue and the time.
Erwin, we are at the end of our time together. Thank you so much for what was so incredibly insightful. I mean, I personally have learned a lot, and I'm sure the community members who have participated have learned a lot. I don't know if you can see on the screen the enormous amount of happy emojis that are going up. There were wonderful comments in the Q&A component as well, acknowledging your contributions. I recognize there were more questions that we could take. Thank you, everybody, for participating. I hope we got to the themes of all of the questions that you have. For our community, make sure that you can go review the lecture when it is up on the recording, share it with your friends and your colleagues. The ideas expressed here were really powerful and really important. Erwin, we are very grateful to you again for delivering the lecture, and we look forward to hosting you on campus next year.
Thank you so much for this great pleasure and honor, and I would love to come be part of the campus sometime soon. Thank you all so much.
Have a good one.